Yep.
All right, this is case number 03145319. This is People Driven Credit Union versus Marcellus Travers. Travers, yes. The matters before the court looks like on the filing of a motion, and just taking a look here. Motion to dismiss garnishment. The record should further reflect in this matter that a judgment was entered in this case by default in 2004. That judgment was renewed at a subsequent time. Upon entry of this matter, the judgment was some $20,000. There appears to be an ongoing debt with respect to the judgment in this matter. For People Driven Credit Union, your appearance, please.
Your Honor, Michael T. Mabbitt, P1102 on behalf of plaintiff.
All right, thank you, counsel. Good morning to you, sir.
Good morning, Your Honor.
I'm looking for Mr. Marcellus Travers, please.
Yes, I'm present.
All right, good morning to you as well, sir.
Good morning, Your Honor.
So I see a motion to dismiss the garnishment, Mr. Travers. There's, of course, a judgment that's pending against you and has been for some time. Why do you feel that the garnishment should be dismissed, sir?
Because I had no prior knowledge to this. This isn't my loan from the credit union. I've been, I don't want to say I've been a victim of identity theft or fraud from my family, but it's been revelations that has been coming along the past 2 years that proves that. Last time we were in court, I presented you with a police report for some items, some monies that were stolen from me, a credit card that was put in my name from that household. And I believe this has been going on ever since my mom passed in 96 and all the way up until the time I was in college. And I just had no knowledge of it. And I wasn't physically served because I wasn't living at that house on 205-64 Foss during that time. So this year is the first time I've been hearing about this. So ever since I heard about it, I've been proactive about it, about getting it resolved and hopefully dismissed.
All right, counsel.
Your Honor, good morning. What the defendant's attempting to do is attack the underlying judgment by attacking the garnishment. However, that's strictly prohibited under the MCR. 1, 2, there's already a payment plan or a payment in order for installment payments in place where the defendant's paying $200 a month at the request of the defendant. And 2, by attacking the underlying judgment, he's attempting to show that because a credit card and a stimulus check from 2021, he believes were taken, that this account was opened fraudulently as far back as 2001. However, the two are so factually dissimilar that one bears no relation to the other. He's presented no evidence of any fraud having occurred when this account was opened 20 plus years ago. And the defendant just mentioned that this is the first he's heard of it. And Your Honor, if this matter wasn't being live streamed, I was able to obtain certain documents from my client, including the notes of a phone call between the defendant and my client in 2018, where the defendant notes it's his account. He just doesn't like how it was handled, and he doesn't believe that it was supposed to be sent to collections. That was in 2018.
All right, so there was it looks like there were a number of income tax type garnishments that were at least attempted over the years as a part of this. Is that correct, counsel?
That's correct, Your Honor. Our records only go back to, I believe, 2014 when we transferred everything to an electronic database. But I believe since the date of judgment, a number of garnishments have been filed.
Yeah, I'm looking at the register of action that shows income tax garnishment issued in, as far back as 2004. And then every year thereafter.
Yep.
So.
Your Honor, I had
I'm sorry, Mr. Travis, go ahead, sir.
Your Honor, I had no knowledge of that. The only knowledge I have that was my income tax was being taken from me was because of student loans. I had no paperwork saying that this was going towards a fraudulent loan from a credit union. Only to my knowledge was that it was going to student loans, which student loans have been taken out of for my income tax since 1998, 1999. This happened in 2003, 2004. So I had no knowledge of that. I have my credit report. This isn't even on my credit report. I just had it checked twice since May, since all this has been going on. It's not even on my credit report. So the knowledge that he's saying that I know that this is from my income tax, I had no knowledge of that. I'm thinking that was being taken out and going towards student loans, which I'm still currently paying on to this day.
All right, so so tell me about 2018. You spoke with someone regarding this debt?
Not to my knowledge. I haven't been in contact with that credit union since early 2000s. I haven't spoke to anybody about this matter in the past 5 years, 4 years. I have no knowledge of that.
All right, so who did you talk to about this in early 2000? What was that conversation about?
Because I used to be a member there, and I had an auto loan in 1998 that was taken care of, just like I take care of all my other loans or auto loans in the past, which I have brought a history of that. So this particular incident from 2003 or 4, I had no knowledge of. No knowledge of.
All right, thank you, sir.
And one more thing, he said I had voluntarily. He said I've been paying on this just because it was a court order from the judge to pay it voluntarily. So I'm just following the court order. I'm following what I was told to do since this has been going on since June. So the $200 he's talking about is what I was ordered to do voluntarily to pay until this matter is hopefully dismissed or dispersed. I understand this is an 18-year-old a debt, 18 years. In 2022, this is my first time hearing about it. That's why I've been so proactive on it. If I've heard about this 18 years ago, I would have been proactive on it then. So,
All right, thank you, sir. All right, two things, probably two or three things. The first thing is that under the statute, if your attack is against the underlying judgment, of course, you have to bring a proper motion that addresses the underlying judgment. This is really one that sounds in an attack on garnishment. I've treated it as a regular motion, however, because it says motion to dismiss garnishment / judgment, but this really arises as a result of an effort to garnish. So under the court rules, you have to do something separately to go after attacking the judgment. But beyond that, and that's kind of the first issue that is not properly before the court. Beyond that, I've got a judgment that was entered many years ago, as has been reiterated by respective parties. I have a file that shows that there were numerous income tax garnishments, which says that through reasonable investigation, one would be able to know that there is this outstanding judgment, because for 10 years in a row or so, there was a garnishment against income taxes. It's certainly been brought to my attention by the petitioner in this matter that he has other financial issues that have been a challenge along the way, and that's understandable. However, if you're being garnished, income tax or otherwise, then you have a duty to find out what the nature of those garnishments are. And you can't allow those garnishments to occur. And then many years later, say, I never heard about this debt, because every time that you're garnished, that is notification that there is an outstanding debt. And then the final thing, and I guess that's the point number 3 here. Point number 3 here is that to the extent that this is a fraudulent debt, it becomes the duty of Mr. Travers to establish that it is a fraudulent debt. There was the judgment was entered by default. It was not an answer. There have been many years that have been passed by. Then there have been a number of garnishments that have occurred over a period of say 18 years. And it's Mr. Travers' duty to establish affirmatively that there is a fraud or something that has been perpetrated against him. He indicates that some members in his family may have done something. He also indicates that quite recently that he filed a police incident report, but those do not go far enough in establishing that there is any fraud that has occurred here. Maybe there was, but there was nothing to demonstrate that. And if he's going to get the judgment set aside, which is what the issue would be here, not so much the garnishment, the issue would be getting the judgment set aside. If he's going to get the judgment set aside, then he would have to show that there is a basis for doing that. And that would have to show, I believe that the position that he's taken is that the debt is as a result of something that occurred fraudulently. There's nothing that establishes that affirmatively in front of me, although Mr. Travers does have the right to bring a proper motion and to raise that issue. How he gets to that issue and provides proof that is sufficient to set aside the judgment, I don't know. But then that's not, that's not for me to know that at this point. Maybe there is a way to do that. Maybe there are people that will sign off on something saying that they created the debt, that they fraudulently did it. But he's got to have something. Just coming in and saying that I don't remember this debt, or someone may have defrauded me and somebody in my family may have done something, and filing a police report on that, that's not enough to establish that particular predicate. But again, you'd have to bring Mr. Travers would have to bring a proper motion in that regard, and then would have to meet the burden of proof to establish that there is a basis for setting the judgment aside after all of these years. And that basis, as he seems to raise, is a basis in fraud. He doesn't have anything to prove that. And he doesn't have it today, but that doesn't mean that he can't develop that in the future. To the extent that he does, I'll be happy to visit that. Right now, he doesn't have anything to establish that, and the case is not properly before the court, although the court was willing to take a look at it as best as I can, because obviously I don't think that anybody, any decent person wants someone to be dealing with a debt or obligation where they can prove that it's not theirs. That's simply something that Mr. Travers has not been able to prove before the court at this time. But for the reasons mentioned, then the court will deny the motion at this time. That motion, of course, is denied, and that's not a prejudicial denial. That means that you can bring the motion again. You can bring a motion trying to attack the underlying judgment, a motion to set the default aside, whatever form you want to put it in. You can bring such a motion, and you would have to then establish by affidavits and other documents some type of predicate for fraud that may justify setting the judgment aside. Otherwise, I find no basis to set the judgment aside, and that is my order at this time. The motion will be denied. I wish both sides well. Good day to you.
Your Honor, real quick, would the court entertain a verbal motion for costs? Just given that this was the second hearing on this matter.
I'll deny the motion for costs at this time. I think there was some important questions that are raised. Moreover, this did bring the matter to a place where the court in the interim has put in place a order for partial payments. And maybe at some point, the defendant can present something that establishes a basis in fraud. If he does, I'll address it at that time. If he doesn't, then I'll consider costs. The matter is brought back to the court at that time. That is my order. Good day to both sides.
Your Honor,
Thank you, Your Honor.
let's say one more thing.
Yeah, go ahead, sir.
The documents that I presented to back up this claim of fraudulency is the email I have from the IRS and
Let me stop.
identity theft saying
Well,
that I was a victim. Excuse me.
okay, you heard my ruling. You disagree with it, but you heard my ruling. That's not enough. You don't have enough here to establish that. You just don't. And you can go
Okay.
back and look at it, you can figure out what you need to do. Maybe there's some other things you can do, but you don't have enough that you presented to the court to establish that this was fraud. And I've taken time to try to hear it because I know that there is something in your heart that you believe that that's what it is, and maybe it is, but there is nothing to establish that. You don't have anything that rises to the level at 18 years later to establish that this was fraud. But I'm willing to listen if you can put together something that is sufficient to meet that burden of setting the judgment aside. You have to show that there is good cause and a meritorious defense to the claim. A meritorious defense to the claim, the ability to establish that the matter was a fraudulent matter would be a meritorious defense. You still have the challenge of establishing good cause. You said that you didn't know about it for 18 years, and that's why you didn't say anything. But then through reasonable inspection, you could have known, but maybe you can get over that hurdle. But the main thing here is that if you're able to put together competent evidence that can establish that this was a fraudulent situation, then the court will take another look at it and try to get to the conclusion on that. All right, that's my ruling. I have to move on from this matter at this time. Good day to both of you.
Thank you, Your Honor. Have a good day.
Just-
Oh, real quick, Your Honor, would the court like plaintiff to submit the order denying?
Yeah, why don't you go ahead and submit an order, counsel?
All right, thank you, Your Honor.
Thank you, counsel. All right, good day.
Have a good day.
All right, the court now calls case number 21-147-880. This is City of Detroit versus Jesse Lee Mays. The matter is before the court on the, looks like the court set this simply for a hearing at this time. I do see a motion to set aside a dismissal and reinstate the case. Counsel, your appearance for City of Detroit, please.
Patricia Porter, P66989, here for the City of Detroit.
Thank you, Madam Counsel. Good morning to you, ma'am. I'm looking now for Jesse Lee Mays or someone representing Ms. Mays. If you're on the Zoom, please say something at this time. Jesse Lee Mays, a person living in Clinton Township, Michigan. If you're on the Zoom somewhere, please say something at this time. All right, Madam Counsel, what's going on here?
Well, what's going on is that a default was filed. It was entered in January 31st, 2022. And a default judgment was filed but rejected in February of 22 because there needed to be a notice of default. So as the court clerk instructed, we filed a notice of default on February 10th, but it never made it onto the register of actions. So we provided proof in our motion that the notice of default and service of the notice to the defendant was filed on February 10th. The dismissal was entered at the same time as the notice of intent to dismiss about a month later, a little over a month later, on March 15th, 2022. We received that notice of dismissal on the 25th of March and filed a motion to set aside because we filed a notice of default that was never entered. So the court was apparently unaware that the requested notice of default had been filed and the dismissal was a mistake due to clerical error of not placing the notice of default on the register of actions so that the court or the court clerk, because I believe it was administrative dismissal, would be aware of that.
So looking at your documents and indeed looking in the court's file, I do see the notice of entry of default. It looks like that was back sometime in 2021. and I see the markings, the timestamp of the clerk of the court scratched out on those documents. It almost looks like those documents were rejected. All right, before you speak, Ms. Porter, who is that is unmuted? Are you on this case? Is that Mays? All right, Ms. Porter.
Yes.
Yeah, so it looks like the default request documents were rejected or something because the timestamp was scratched out.
So what happened, if I may, the default judgment was rejected on 2/4/22 with the instructions that you need to file a notice of default first, which we did about how many days later, maybe 6 days later, a notice of default was filed on 2/10/2022. And despite that notice of default being filed, a dismissal was entered about a month later. It should have been, the notice of default should have been entered on the Register of Actions and on the court records, and then we would have been able to file our default judgment. We needed to wait, according to the court rules, to file the default judgment until the notice of default was entered. So in effect, we've been precluded from filing our default judgment that we wanted to file because there was no notice of default entered, and instead a dismissal was entered.
All right, under the circumstances set forth on the court's review of this matter, the court will reinstate the case at this time. The court will accept the filing of the notice of default that has attached to it a proof of service indicating that the notice was tacked onto the front door per the order of the court. And that notice is dated 10/25/21. Looks like the court entered it on 11/17/21. It looks like the proof of service regarding this matter is that's looking at the earlier proof of service. Just one moment.
Excuse me, Your Honor. There was an earlier filing of this case, and I'm wondering if you're looking at a Register of Actions for the 2021 case. This case was filed 2/17/2021. Is that the register that you're looking at? Because some of these dates you're quoting are in 2021, and all the filings that I'm talking about are in 2022.
Oh, that's all I'm seeing is, yeah, that's what I was concerned about, because this is a 2021 case. Looks like
C-O-L-E.
it looks like I allowed alternate service back in July of 2021.
Yes,
Okay.
correct. And then service was personally served after that date within the time for service. We tried again and got personal service.
All right, very well. Well, I'm satisfied that that service has been completed in this matter, and a notice has been given regarding the request for entry of default. And the case having now been reinstated, I will grant your petition for entry of the judgment by default at this time. Notice of default having previously been given.
Okay, that's great, Your Honor. Thank you very much. I'll submit an order.
Thank you, and the court will sign the order upon presentment.
Thank you.
Put in the order the order reinstating the matter, if you will.
I will. Thank you.
She's working.
171768. This is Auto Club Group versus Deandra Fields and Cedric Fields and Deanna Lucas, I'm sorry. The matter is before the court, set on for a pretrial conference on today's date. Your appearance for Auto Club, please.
Yes, good morning, Your Honor. Dylan White, P80755 for Auto Club Group.
All right, thank you, counsel, and good morning to you, sir. Do I have, who do I have here on this matter? Say your name, please.
Deandra Fields.
All right, is it Fields or Lucas? Oh, no, Deandra. Okay, I got you. All right, thank you, Ms. Fields. Good morning to you.
Good morning.
All right. So do I have Cedric Fields or Deanna Lucas on the Zoom?
Yeah, they're
Yes,
right
you
here.
do.
Good morning, Your Honor.
Cedric Fields here.
Good morning to the three of you. All right, counsel, update me on this matter, please.
So it looks like, Your Honor, previously to this hearing, there was a pretrial hearing where a pretrial order was set, discovery to close by this date, and this was another pretrial hearing to probably get an update on where we're at with discovery and where we're going to go forward.
That's correct, sir. So, so give me some information in that regard. Has there been an exchange of information, discovery requests sent out? Talk to me.
So as it stands, we did send out discovery requests, and just this morning, we received answers to those discovery requests. But we did not receive any discovery requests from defendants.
Got it. So, so you need time to review whatever submissions you receive, correct, counsel?
Yes, Your Honor.
All right. So, Mr. Fields, Ms. Fields, Ms. Lucas, so you didn't submit any documents requesting any information from Auto Club, is that correct?
The only thing that we ended up getting
It's just the one for you.
was just the one paper for me, like the questions and yeah, it was like the questions and answers type of thing.
Yeah, interrogatory. You received those from Mr. White, but you guys did not request anything of Auto Club. You didn't send any questions or requests for documents or anything to them.
No.
No.
Is there anything that you need from Auto Club? Any information that you might need if this case goes to trial?
We'd like to know, we'd like to know what their documents.
Well, we would like to know their
answer questions.
documents and stuff like this.
Wait a minute, one person at a time. What did you say? Go ahead.
Well, do we have the same, I mean, because we had to, well, she answered the questions of like the,
Yeah, no, I'm not talking about that. Okay, you apparently you responded to those documents and Mr. White is going to review them and decide whether or not he wants to file a motion or what his client believes they should do next in that regard. My question to you was whether or not there was anything that you were requesting, just like they requested some stuff from you. Is there anything that you're requesting from Auto Club? Any information that might be helpful to your case? Anything along those lines?
well, I don't know if they answered the same questions as we did. Can we get their responses?
No, you didn't send them any questions.
No.
That's what I'm asking you
Oh.
about. So, I'm not trying to complicate this, but today is the last day for discovery. So my question is, are you asking the company to send you a copy of any documents? Are you asking for them to send you any information that they may have under their control that you would be able to take a look at? Is there anything you're asking for?
If that's possible, yes. What you just said, if there is, if the information that they have, if they could email us.
What information do you want?
What was her response as far as how so-called the four-way stop, what was her response?
Who is her?
The lady that was driving the vehicle. Because I believe it was her dad's vehicle and there was a female driver and her boyfriend in the car at the time of the accident.
They would like the submission of any documents tending to show other persons who may have been involved in this automobile accident incident, and any investigation as a result of those involvements. And so if you can submit that information in the next 14 days regarding this particular claim, sir.
Very well.
All right, anything else you're requesting?
No, that is all. Thank you, Your Honor.
All right, thank you. All right, so the next step is that discovery will close out after that document is after that information is exchanged, and then I will take a review of the matter at the next action date to see exactly where the parties are and if this can be resolved. And if not, we'll set it on for a proper trial. So the next date I'm going to give you is going to be about 30 days hence.
You said 30 days, October, the 19th?
10/19/22. That's going to be at 9:45 a.m. 10/19/22, 9:45 a.m. will be the next date that you'll need to zoom in.
Your Honor, as a quick matter of housekeeping, we received the pretrial scheduling order, but it looks like we only received the first page. The second page mentions motion date file deadline. Do you happen to have that on hand that maybe we could get from you?
I looked in, I didn't see the second.
All right, for some reason, the second page didn't populate, but what happens is that I typically allow for motion filings to be heard on the date of pretrial, so long as the other party has at least 10 days to respond to the motion. So what I'm going to do is I'm going to go ahead and set a motion date now. Let's move that date ahead just a little bit.
October
Let's move it into the first week of November.
November. Oh, you want it in November? Okay, so
So we're going to change the date.
Okay.
November 2nd.
November 2nd, 2022. November 2nd, 2022. And that's going to be at 10 o'clock a.m. That's the next action date. Any person that wishes to have a motion heard in front of me can file a motion and set it for hearing on that date at 10 o'clock a.m. The only requirement is that you have to allow the other party to have at least 10 days to respond to the motion. So if Mr. White files a motion, you will need to respond to that right away, because you'll need to respond to it before the hearing date. And then likewise, Mr. White, of course, if they file a motion, you'll need to respond to it before the hearing date. And any motion that is filed, I will hear it and make a decision on it on the 2nd of November, 2022 at 10 o'clock a.m. Right? All right, so I wish all sides well. You be sure to be here at 10 o'clock on the 2nd of November. And again, within the next 14 days, the documents requested by the defendants in this matter, Mr. White's office is going to send that information to you so that you will have that available. All right, I wish you well. Good day to each side.
Thank you, Your Honor.
Thank you, Your Honor.
The court now calls case number 22-178921. This is Madison Heights Imaging versus City of Detroit. The matter is before the court set on for a pretrial conference date on today's date. It looks like I did do a scheduling order regarding this matter and set for today for pretrial and also the close of discovery. Your appearance for the plaintiff in this matter, please. For the plaintiff, do I have plaintiff on this matter? For defendant, City of Detroit?
Patricia Porter. P66989, appearing for the city.
All right, thank you, Ms. Porter. Good morning again. What's
Good
going
morning.
on here? Don't see the other side.
Yeah, I don't either, and I didn't notice that they weren't on, or I would have given them a quick email or a call. The discovery cutoff, as the court mentioned, is today. We did send discovery. We haven't received any responses, including a notice of the rate setter's deposition. So we'd like to have some time to get those responses if this case is going to go forward. And that's really the status as far as I know.
So I could set it over for 30 days to try and close the loop on that, or you could take a moment to try to reach out telephonically to see if the other side wants to try and come in and drill down on what's going on with getting the responses.
Sure, I would be happy to do that if the court would like me to try and reach them.
Yeah, I'll stand down for a moment and come back to you, Ms. Porter.
Okay.
Let me know. Okay,
All right.
thank you. This is case number 22-181426. This is Citibank versus Benoit Hicks. The matter is before the court set on for a pretrial conference date on today's date. Your appearance for the plaintiff regarding this matter.
Yes, good morning, Your Honor. Joseph Jamal on behalf of the plaintiff, P71254.
All right, thank you, counsel, and good morning to you, sir. Do I have Benoit Hicks on the Zoom? If you're here, please say something at this time. I'm looking for Mr. Hicks. Reportedly lives in the city of Detroit on Maiden Street. If you're on this Zoom anywhere, please say something at this time. If you are on mute, you can hit *6 and unmute yourself. Please say something at this time if you're here. All right, I see, counsel, that you filed a motion for summary disposition regarding this matter. Let's see. I think I set a scheduling order or something up regarding this matter at one point as well. I opened discovery until today's date and allow for the filing of motions to be heard on today's date. So have you spoken with Mr. Hicks recently, or update me on where things are regarding this matter?
Yes, Your Honor. So previously, the defendant at hearings had indicated that there may have been some fraud involved in this case. Discovery was granted at that last hearing back, looks like it was July 5th. We did hear from the defendant on July 11th, requesting certain documentation and verification of the account. We did send out both this motion as well as discovery requests. Those were sent out, looks like July 18th of this year. We have not received any sort of response, any further indication regarding the fraud, any sort of support for that fraud. Thus, we proceeded with this motion for summary as well.
All right. Again, Mr. Hicks, if you are anywhere on this Zoom at this time, please say something. All right. It appears that the defendant has not appeared for this hearing, and the court gave notice on the record, and notice was sent by the court regarding this date as well. That notice was sent out on July the 5th, indicating today's date and the time at 9:30. It's now 10:23. Defendant has not appeared. Your pleasure at this time, counsel.
Yes, Your Honor. We'd like to move forward with the motion for summary disposition based on the fact that we've provided detailed account statements regarding the balance and support of the account. It appears that those statements were sent to the defendant. We don't have any indication of objection sent to those statements, nor have we received any support for any of his claims regarding his dispute regarding the matter. As such, we don't believe there's a meritorious defense.
All right, the court has read the motion for summary disposition and heard the arguments thereon. And the motion sounds in the proposition that the defendant failed to state a valid defense upon which he could assert this matter and could defend in this matter. The defendant attempted orally to raise issues of fraud, but has not offered anything to ground the same. Accordingly, the court finds that there has not been the statement of any valid defense as required by the appropriate court rule, and that therefore, for failure of any defense to the claim, the motion for summary disposition will be granted, and the court will enter judgment upon the granting of the motion for summary disposition. The court would also note that the defendant did not provide any written response to the motion. And again, I reiterate that the defendant has not appeared for the hearing on the motion. The motion is granted, and the court will enter judgment upon presentment. Did you attach a judgment, a proposed judgment, counsel?
We did not, Your Honor. I can send that either in under the 7-day rule, or if there's an email you'd like me to forward that to, I could send it via email. Either way works for us.
Go ahead and send it to the email address I'm going to give you. That's Latifa, LATIFAH.Hunter@36districtcourt.org. Got that information already?
I do. Thank you, Judge.
All right. So go ahead and send that order, and we'll get it all signed.
Have a good day. Thank you.
The court now calls case number 111-26148. This is Harbor Detroit Square LLC versus Diana Hardy. The matter is before the court on an application for issuance of a subpoena. I'm looking for counsel for Harbor Detroit Square LLC. All right, I'm looking for Diana Hardy. If you're on this Zoom, please say something at this time. Diana Hardy. All right, it appears that the defendant, to strike that the petitioner has not appeared. It also appears that the respondent has not appeared. Given that the petitioner is not present, the application and issuance of the subpoena will be set aside. The subpoena is dismissed at this time.
Well, Judge, you don't have to go home. There's no case today.
Oh,
Yeah, tomorrow.
now, I think I'm supposed to sign stuff too.
Yeah, they have her working in another courtroom.
We'll just do it as a
Yeah.
waiting on this order to see if she made contact with the last. All right, welcome back, Ms. Porter. Go ahead and update me if you got any information on the Madison versus City of Detroit.
Yes. Thank you, Your Honor. I was able to contact plaintiff's office. It's the Dwin Bazzi office, and the receptionist told me she was going to have someone sign in. She didn't have that person's name, so hopefully someone will be joining us shortly.
All right, thank you, Council. We'll wait a few minutes here.
Okay.
Well, Council, we waited on this matter and the other side is not here. I appreciate the courtesy of calling that office and trying to bring them in on this matter. I guess I'll go ahead and grant the adjournment for 30 days to review this matter. And I suppose I'll take under advisement a petition to dismiss the matter and giving them an opportunity to respond to the discovery and to show up at the next hearing. And should they not do both of those things, then I will review your petition, but it looks like somebody's coming in.
Yes.
All right, we're on the record in 22-178-921 Madison Heights Imaging Center versus City of Detroit. And Madam Counsel, Ms. Porter has entered her appearance on this matter for defendant City of Detroit. For the plaintiff in this matter, your appearance at this time?
Mohammed Hamoud, P number 86140.
Mr. Mahmood, good morning to you, sir. Yeah, this was set on for 9:30 this morning. It's almost almost 10:40. What's going on, sir?
My apologies, Your Honor. I don't know. I was just given this, I was just told to just hop on. So I mean, there must have been some kind of miscommunication. This is, something that is not mine, but no excuse, Your Honor.
All right, gotcha. All right, so I understand Ms. Porter brought us up to date on this matter by pointing out that I did sign the discovery order that allowed discovery through today's date. And I believe she indicated that she sent out some discovery requests and was waiting on information to come back. And moreover, was asking for a little additional time to get those answers back. That's kind of like the posture of the case. Ms. Porter, anything else, ma'am?
No, Your Honor, that's correct. Discovery was served in July. Answers were due, a notice of deposition, interrogatories, and requests for production of documents. And responses were due in August, and we did not receive any responses. So if the court would issue an order compelling responses, that would be helpful.
Counsel, anything?
I have no issue with that. I'll get on the discovery team and have those answers to Ms. Porter as soon as possible.
Given the fact that the responses are passed through, I will grant your petition compelling answers to discovery. And I'll order that the outstanding discovery be submitted within the next 21 days. So I'm going to set a hearing to see where we are with this matter about 30 days out. So that's going to put us at that October 19th date, 10/19/22. I'm going to set that for 9:45 a.m. And Ms. Porter, if you'll submit an order compelling discovery, that would be great, so that everybody's on the same page.
Yes, thank you, Your Honor. I will do that.
All right, thank you. Good day.
Thank you. You
Thank
too.
you.
That's what you said before. Yeah, but this ain't got nothing to do with me.
All right, thank you, Madam Reporter. How are you today?
Hello, Judge. I'm fine. How are you?
Good. Well, we got Monday started off right, I suppose.
Right. So we're all done today. And
We're all-
I'm with you tomorrow also.
Okay.
We all
All
finished
right,
for
we'll see you at that. Someone else is coming. Who is that in this Zoom? Tell me who you are.
Hello,
Yes, who are you?
my name is Benoit Hicks, and I tried to get on at 9:30, but I could never get no connection.
Well, I've already made a ruling and I've made a ruling in your case. What you got to do is you're going to have to file a motion on the second floor to try and get that case back in front of me, but I already made a decision on that case.
What decision did you make?
I don't even remember at this time. I think I granted their motion.
You did grant the motion for summary disposition, Judge.
Right, their motion for summary disposition was granted, which means that they're going to be able to receive a judgment against you. But you filed a motion, a written document on the second floor, and explain why you were not in the hearing at that time, and I'll consider your reasons, sir.
Okay, so you said go to the second floor, 36th District building?
Yes, sir. And you want to file a motion to set the order aside.
What you asked?
This is his wife, Judge. We have to file a motion and set the motion aside so that you can relook at the case again or redecide or something.
To set the order aside.
Yeah.
File a motion to set the order aside and put on the motion the reasons why you were not heard on today's date.
Okay.
Document what happened, okay?
Yeah. Okay, to document what happened. We have a trouble. We're not literate on this system here that you're using. So we had trouble reconnecting. We can hear you very clearly in the court in the cases before and after. The court couldn't respond to us.
So when you file you don't have to file a document. When you file a document, point out that you were on the Zoom, but you were not able to come off from mute to be able to engage. And,
all right.
And that was why you were not heard on that date. Okay. Get that
all right.
file.
Do we have a time span to put this file in motion?
It would be good if you could get that file this week so that I can. What you have to do is send a copy to the other side, to the attorney on the other side, and then get a copy to the court. And then I'll take a look at it and set a hearing on it, okay?
All right, then. Thank you so much.
All right, thank you. I wish you well.
You as well. Bye-bye.
Hey, have a good day, everyone. See you tomorrow.
You too.
All right, thank you. Bye-bye.